by the writ of summons dated and filed on the 18th day of April 2018, the claimant, as per paragraph 21 of the statement of claim, is praying for the following reliefs. They are: 1, a declaration that his purported dismissal is illegal, unconstitutional, null and void. 2, an order of this honorable court directing the defendant to restate the claimant back to his duty employment as a driver in accordance with the terms of his employment. 3, an order of this honorable court compelling the defendant to pay the claimant's salaries at the rate of 63,000 naira per month from the month of his dismissal, i.e. March 2017, until judgment is given in this case, to be calculated and arrived at certain sum and the allowances in respect thereto. An order of this honorable court declaring that the claimant did not violate any of the rules of the defendant as contained in the rules and regulation of service of the company. 5, an order directing the defendant to pay the claimant damages and such other inconveniences plus the loss of earning at the sum of 100,000 naira per month from the month of purported dismissal until judgment is finally given. In the alternative, 1, an order directing and compelling the defendant to pay the claimant his entitlement and gratuities, having served the defendant for 8 years, i.e. from 21st day of February 2011. B, an order for the payment of general damages at the tune of 20 million naira only. C, the sum of 2 million naira as being cost of this suit. Upon being served with the originating process commencing this suit, the defendant entered a conditional appearance, and followed it with a notice of preliminary objection. The claimant responded by filing reply in opposition to the notice of preliminary objection. The defendant, on the 7th day of November 2018, filed statement of defense dated 5th day of November 2018. The said statement of defense was deemed properly filed and served with the leave of this court. The claimant testified in proof of his case as CW1. He tendered documents which were admitted in evidence and marked as Exhibit A, B, C, D, and E. At the end of evidence in chief, CW1 was cross-examined by the counsel for the defendant. Thereafter, the claimant was discharged. The defendant on his part called 3 witnesses in his defense. 1, Joseph Nengak testified as DW1. Pamela Wakama testified as DW2, while Bamidele Amusu testified as DW3. These witnesses tendered documents and they were admitted in evidence and marked accordingly. They were all cross-examined by counsel for the claimant. Thereafter, they were all discharged. The case of the claimant, I shall skip reading that portion to save time. The same thing with the case for the defendant. I shall also keep reading the submissions of counsel. The submission of counsel, the counsel formulated 2 issues for determination. They have been captured in the body of the judgment. All the argument canvas are contained in the body of the judgment. I will go straight to the decision of the court. I have considered the processes filed in this suit, the evidence laid by the parties in proof of their respective positions regarding this suit, as well as the written submissions of the defendant and oral submissions of counsel for both parties on the day the adoption of final addresses was done. Hearing in this suit commenced on the 28th day of June 2018. However, due to the transfer of the judge handling the matter on the 30th day of October 2019, the hearing commenced before me de novo. At the close of the trial, parties were ordered to file their respective written addresses. The defendant filed its written address dated 10th day of December 2020 on the 16th day of December 2022. After 5 adjournments without any of the parties being in court, or being represented by counsel, on the 10th day of February 2022, when this matter came up for adoption of final written addresses, the counsel for the claimant appeared and informed the court of receipt of the dependent final written address. However, counsel informed the court that the claimant did not file his final written address as he would be relying on the wisdom of the court. Counsel also urged the court to deem the final written addresses of the final written address of the dependent filed on the 16th day of December 2020 as argued. The counsel for the defendant has formulated 2 issues for resolution. One, preliminary issue, and the other, the main issue for determination. The issues are: 1, whether the failure of the claimant to sign the originating complaint as well as the failure of the claimant to accompany the originating complaint in this suit with purported dismissal letter terminating his appointment with the defendant is not fatal to the jurisdiction of this honorable court to hear and determine this case, whether in view of the pleadings and evidence laid in support of the same, the claimant has proved the case to be entitled to relief sought. However, before proceeding to delve into the issues formulated, I shall at this juncture observe that from the processes filed, it appears counsel for the claimant did not take his time to read and digest the rules of this court, because in the originating processes file was titled writ of summons, and one of the accompanying processes was titled statement of claim. It is clear by virtue of Order 3 of the rules of this court that one of the means of commencing an action before this court is by way of complaint. Another way of commencing an action is by way of originating summons. There is also application. There is also petition. These modes of commencement of action were provided under Order 3, and none of them has made provision for writ of summons and statement of claim. What the rules provide is for an intending claimant to file his action before this court is to go by a way of complaint, and the complaint shall be supported by statement of facts, list of witnesses, list of documents to be relied on, witness statement on oath, and photocopies of the document to be relied on. There is also the requirement for filing a schedule containing all the intended document to be relied on as exhibit before the court, so as to give the other party proper notice as to the nature of the claimant's case. However, the claimant in this case decided to choose to go by writ of summons, which is not one of the means of commencing an action. However, by virtue of Order 5 Rule 1, I consider the action of the claimant in entitling his processes with wrong title as a misnomer, which does not go to the root of the case. Counsel is advised whenever is advised whenever preparing to file an action, not even before this court, to as much as possible try to read and master the rules of the court where he wanted to file his processes. I shall say no more on this. The dependent abuse. I shall now consider issue 1, which was titled preliminary issue, which is not the main issue. It is an objection by the defendant to the competency of this suit. The defendant, upon being served with the originating process commencing this suit, filed memorandum of appearance dated 2nd day of May 2018, on the same day wherein the defendant in this case, in this suit, enter a conditional appearance. Following the entry of conditional appearance, the defendant filed a notice of preliminary objection dated 9th day of July 2018 and filed on the same date, wherein it was prayed for striking out of this suit for lack of jurisdiction on the ground of non-fulfillment of condition precedent to the filing of this suit. The notice of preliminary objection was supported by a written address on the 19th day of July 2018. The claimant, through his counsel, filed a reply to the notice of preliminary objection, objecting to the said preliminary objection. For the reason best known to the counsel, the notice of preliminary objection was not argued before the court, and counsel decided to proceed to trial. The issue raised in the preliminary objection was again raised in the final written address. However, I shall consider the issue since it borders on jurisdiction, as the law is right that issue of jurisdiction can be raised at any time, at any stage, and before any court, whether at trial or at appellate level. In the circumstances, I shall give consideration to issue 1, which is challenging the jurisdiction of this court. In arguing the preliminary objection, counsel argued that for a court to exercise jurisdiction over an action, certain preconditions must be in place. Counsel, to support this position, counsel refers to the case of Madukolo versus Ikendili, where 3 conditions were provided which are to be fulfilled before an action can be commenced. Counsel submitted that all these 3 conditions must coexist before a court can be said to have competence and jurisdiction to entertain the matter before it. On the other hand, the absence of any of the conditions will be fatal and will render the proceeding, however well conducted, a nullity. On this contention, counsel referred to the case of Akim Benin versus Thompson. According to counsel, in the instant case, the originating complaint is not signed. The originating complaint in this suit was not accompanied with the purported dismissal letter terminating the claimant's employment with the defendant, as required by the rules of this court. The claimant also admitted during cross-examinations that he did not tender a letter of dismissal, and none is before the court. Counsel submitted that the failure of the claimant respondent to comply with the mandatory requirements of Order 4, Rule 4 sub Rule 2, and Order 4, Rule 4 sub Rule 3 of the rules of this court, and Order 3, Rule 13 of the rules of this court, which requires filing of letter of dismissal whenever dismissal is issued. Counsel submitted that the words used in the provisions of Order 4 and Order 3 are mandatory rules. They are clear and unambiguous, they are straightforward, and they should be given their literal meaning. They should therefore be given their ordinary and literal meaning, particularly with use of the operative word shall in them. In support of this contention, counsel referred to the case of Senator Joy Emodi versus Honorable Alphonsus Ubangibeke and 5 others. Counsel concluded that the complaint originating this suit not having complied with the condition precedent to the commencement of this suit shall be struck out from the docket of this court, as the court has been deprived of the jurisdiction to entertain the suit. Counsel asked the court to strike it out and also rely on the case of Okoye versus Nigerian Construction and Furniture Company. He also relied on CBN versus Kato. As pointed out earlier, the claimant has not filed final written address. Therefore, no argument has been canvassed by the counsel for the claimant in opposition to the preliminary objection. This may be taken to mean counsel has no response to make, and the reply which was filed by the counsel to the notice of preliminary objection has not been moved. In resolving this issue, it is clear that the issue seeks to contend that this court was robbed of jurisdiction to entertain this suit on the premise that the writ was which initiated the suit before the court was incompetent and thereby denied the court of competence and jurisdiction to entertain the suit in the first place. The incompetency that affected the jurisdiction of the court, counsel argued, is premised on the fact that the writ of summons by which the action was commenced was not signed by the claimant himself or by his counsel, as provided for under Order 4, Rule 3 of the rules of this court. Jurisdiction has been held by the Apex Court in numerous cases to be fundamental to the competency and adjudication processes. It is likened to the blood that gives life to an animal, and where the court is devoid of or is lacking jurisdiction to try a matter before it and proceed to do so, whatever decision arrived at will amount to a nullity. And the fact that it was well conducted and result brilliantly arrived at, it remains a nullity. See the case of Olobo versus Akereja. See also the case of NURTW versus Retain. In Madukolo versus Inkendelim cited by counsel, it was held that a court is competent. 1A, it is properly constituted as regard numbers and qualification of members of the bench, and no member is disqualified for one reason or another. 2, the defect in the subject matter of the case is within the jurisdiction of the court, and there is no feature in the case which prevent the court from exercising its jurisdiction. It is clear, therefore, that any defect in competence is fatal for the proceedings. For the proceeding will be a nullity, however well decided. In the case at hand, the writ of summons which originated the action before this court can be seen at pages 1 to 3 of the case file. From the originating process, commencing this suit dated 18th day of April 2018, the claimant commenced this suit via a writ of summons accompanied by a statement of claim. The writ of summons is at page 1 to 3 of the case file. It was said to have been issued by one J.M. Kalamu Esquire, and it was not signed by J.M. Kalamu Esquire and co. The solicitors to the plaintiff, whose address of service was given as number 17, Fari Clinic Block, Suleiman Barrow Road, Suleja, Niger State. I quite agree with counsel for the defendant that by order 4 to 3 of the rules of this court, an originating process commencing this suit before the court must be signed by counsel for the claimant or the claimant himself if he is not suing through a counsel. In the case at hand, from the process is filed, the claimant is suing through a counsel by name J.M. Kalamu. In the circumstance, be signed by the said counsel for the claimant. The reference, however, that was not the case. The reference to counsel in the rules of this court means, by virtue of the interpretation section 1, means a legal practitioner by virtue of the provisions of Legal Practitioners Act. Taking into consideration this interpretation, the meaning of legal practitioner or counsel, section 2 and 24 of the Legal Practitioners Act are very clear and unambiguous, and it has received consideration of the Supreme Court in numerous cases, such as Okapo versus Nweke. It was established that any document process for filing in court, not just an originating process, must be signed by a person qualified to practice under the Act. Any other mode of signing and authentication of a legal process will render the process a nullity. See the case of First Bank of Nigeria and 3 others versus Maiwada. See also the case of Alawiye versus Ogunsanya. Alawiye versus Ogunsanya. In the case at hand, the originating process commencing this suit was never signed by J.M. Kalamu Esquire, counsel for the claimant. This means that the writ of summons filed by counsel remain unsigned. This is clear violation of the unambiguous provisions of Order 4 Rule 3 of the rules of this court and Section 2 and 24 of the Legal Practitioners Act. Therefore, the originating process cannot be said to have been properly and duly filed before the court. The position of the law in this regard is clear and unambiguous. An unsigned document is totally worthless and is incapable of conferring legal benefit. Unsigned document is not in existence and so cannot invoke the jurisdiction of the court. See the case of Ogu Oko Memorial Farm Limited and another versus Nigerian Agricultural Corporation Bank Limited, reported in 2008 for SCNJ 436. See also the case of Garuba versus KIC Limited. The citation has been provided. See also Rabiu Alpha versus Zachary. Citation also provided. The defect here goes to the root of the action as it affects the bias of the court to adjudicate on it. The writ of summons in this case becomes a nullity upon being filed. It could not ignite the jurisdiction of this court. The jurisdiction of the court remains dormant until the originating process was properly filed before the court to ignite it. If the originating process has not been brought before the court by due process of law, the claimant cannot invoke the court's jurisdiction, and the court will not labor in vain to entertain the said suit. This is the case here. This court lacked jurisdiction to entertain the suit as the process commencing this suit is void ab initio and or it is of no effect whatsoever. In the present case, the defect is not in non-signing of the originating process cannot be treated as an irregularity as suggested by counsel for the claimant in the reply he filed to the unmoved notice of preliminary objection that a party can waive. A party cannot waive the breach, this fundamental defect in the writ of summons, and it is never late in the proceeding to raise the issue of jurisdiction. From all I have been saying above is that the originating summons or the writ of summons as titled by the council cannot invoke the jurisdiction, cannot make the court to adjudicate upon the dispute that was submitted by the parties, as there is no suit before the court, since the originating summons, the process that is to ignite the said processes was not properly before the court. In the eyes of the law, it is non-existent. In the circumstances, I hereby struck out this suit for lack of bias to hear and determine this suit. The consequences of resolving this issue in favor of the defendant has brought the life of this suit to an abrupt end. However, I shall proceed to consider the main issue for resolution to determine the case put forward before the court by the claimant. The reason being that this court is court of first instance. If there is an appeal, the Court of Appeal will have the benefit of knowing the position of this court on the main suit in the main suit. The claimant action is aimed at contesting validity of his dismissal from the service of the defendant. The facts forming the backbone of this suit are very simple and not complicated. I have in the earlier part of this judgment gave my preparatory resume of the facts. The claimant in this suit was in February 2011 employed by the defendant, a limited liability company, as a driver. The claimant was first queried in February 2018 for alleged tampering with SIM device mounted on the truck assigned to the claimant in the course of his employment. The claimant replied the query and he continued to perform his duties as assigned to him. However, on the 15th day of March 2018, another query was issued to the claimant. This query was in respect of embarking on an unauthorized night driving and visiting a suspected bitumen dump site along Oka Inuk Road. According to the claimant, on the 13th day of March 2018, at about 8 a.m., he left Sapale and slept at Oka at about 5:15 p.m. in compliance with rules or other directives on no night driving journey. The claimant left Oka at about 6 a.m. and arrived at Otukpo in Benue State, his destination, at about 10:11 a.m. On the 14th day of March 2018, the bitumen delivered to Otukpo was endorsed as being in order, and he started his journey back to his originating source. The defendant on his part admitted that the claimant has been in the service of the defendant since February 19, 2013, making his service with the defendant to be 5 years and not 8 years as claimed by the claimant. It was also stated that during the claimant's employment with the defendant, the claimant has been issued with several warnings for misconduct. It was stated that the claimant has right to appeal against the disciplinary measure taken against him. It was stated that the claimant did not comply with the no night driving journey directives. As documentary evidence shows clearly, he diverted from his route at prohibited time. The satellite shows claimant visiting illegal dump site. The claimant was given opportunity via a query issued on the 15th day of March 2018 to state his side of the story. After the defendant received the claimant response and on the careful examination, noticed that the claimant's reply was evasive. The claimant response was considered in the light of the documentary evidence available. The defendant considers the conduct of the claimant unacceptable and a clear violation of its rules. The defendant asserts that it was duly informed that the claimant failed to report to work following his response to the query. dated 15th day of March 2018. The claimant has refused to report to work from 16th day of March 2018 till date. The complaint of the claimant is that he was not properly dismissed by the defendant as he had not committed the alleged infraction level against him in the query issued to him. The claimant is relying on his reply to the query in proof of the abandonment that he slept in Oka on the 13th day of March 2018 in compliance with the rules or order directives on no night driving. It is tried law that where an employee complains that his employment has not been properly determined, he has the onerous task to place before the court the terms and contract of employment, and B, to prove that in what manner the said terms were breached by the employer. It is not the duty of the employer as dependent in an action brought by the employee to prove any of this. See the case of Kato versus CBN. See also the case of Amodu versus Amode, where Agbaje JSC as his and West of blessed memory has this to say. It appears clear to me that since it is the plaintiff's case that his dismissal by the defendant is not in accordance with the terms and conditions of contract of service between them, it is for the plaintiff to plead and prove condition of service regulating the contract of service in question. On importance of conditions of service, Wali JSC of blessed memory also, in the same case, put it beautifully as like this. The term of contract of service is the bedrock of the appellant's case. This underscores the importance of employee proving the contract of service because that is what the court must rely on in the course of in determining the rights and duties of the parties, or to determine whether there has been breach or not. It is clear from the above decision of the Apex Court that in a case where a claimant is seeking for declaration that his dismissal by the defendant is illegal and constitutional and null and void, he has an appeal task of proving his case by concrete, cogent, and compelling evidence. And admission in this situation cannot entitle the claimant to the reliefs he is seeking. And it cannot be done by reliance on the weakness of the case of the defendant. The proof must be based on strength of the case presented before the court. The proof shall be the pleading and the evidences that were brought before the court, the conditions of service regulating the contract of service, and the evidence proving how the contract of service was breached by the defendant. It can therefore be stated that the terms of contract of service is the foundation stone on which the case of the claimant must be built upon, because he succeeds or fails based on his own pleading and evidence brought before the court. See the case of Amode Supra. See also Iwuchiku versus Uweze. See also Texaco versus Kende. Therefore, where a claimant is seeking a declaration that dismissal or termination of appointment is nullity, it is incumbent upon him to plead those materials that are regarded to be the main materials facts to be established to succeed on the claim that the contract of service was not properly determined. In the instant case, these material facts are absent, both in the pleading and evidence. The claimant in his evidence in chief has told the court that he was sacked by the defendant. He also adopted his witness statement on oath, which is almost a replication of the pleading. Under cross-examination, the claimant told the court he was issued with letter of employment when he was employed by the defendant, but did not tender it in evidence. The claimant also told the court that he did not tender letter of dismissal because he did not sign for it. He told the court that he does not know why he was dismissed. The claimant could not therefore state, the claimant could not therefore state what the nature of his employment was and under what circumstances the employment could lawfully be terminated or dismissed. A breach of the contract of employment or dismissal of an employment where a claimant believes that where a claimant in a contract of employment sought for declaration that his termination or dismissal is illegal and constitutional, null and void, presupposes the existence of terms of the contract, the conditions of service, which were breached by the defendant. And in the instant case, the claimant deliberately refused to plead and tender the terms and conditions of service. His recourse to the court is a futile exercise. See the case of Moroflo versus Kwara State College of Technology. See also Umo versus LTGC. In any matter involving master and servant, the main function of the court is to interpret the contract of service, if any. Usually the contract service contains the conditions and terms of service, and these include conditions of dismissal of an employee and termination of appointment. And in considering the liability or otherwise of the parties under the contract, a court of law will not venture beyond the confines of the contract of service in search of a greener condition to favor any of the parties. The court must instead construe the terms to bring on the clear intention of the parties and nothing more. Since entering into contract, the parties are taken to have agreed to be bound by the terms. The court is not entitled to look outside a contract of service as to its terms and conditions. These must be gathered therefrom or from other sources which can be incorporated or which have been incorporated by reference to the contract of service by the parties. It is the best and the only deciding the right of the parties under contract of service. See the case of Anasambe versus Bond Limited. See also British Airways versus Makanjola. See also the case of UBN, Ogbo versus UBN. The law is well settled that it is not the primary duty of the defendant to prove that dismissal of claimant is in accordance with the terms of his contract of employment. To say so will amount to putting the cart before the horse. It is rather the primary duty of the claimant who asserts and who is seeking declaratory relief to prove his assertion before the court. This onus of proof will shift to the appellant to justify dismissal if the claimant is able to establish his claim by concrete and admissible evidence. In the present case, the claimant has not discharged the onerous duty imposed on him by the law. The duty or initial burden on the claimant becomes obvious when one realizes that the fact that it is settled law that an employer has the legal right to terminate or dismiss an employee without giving reason for so doing. See the case of NNB PLC versus Osunde. In the present case, the claimant has not collected the letter of dismissal. He also read it and did not sign it. Therefore, this court will not be in a position to decide This means that the claimant is so economical to the facts to the extent that the document that would have helped him to prove his case, he is hiding them. It is, however, the defendant in a desperate move to defend his case has gone ahead to supply the missing links that the claimant has refused to supply the court. The defendant has tendered exhibit DW2A and DW3A. These documents are the contract of service and the conditions of service of the defendants. That is the policy on the termination, appointment, and discipline of employee of the defendant. However, the ominous situation cannot be created, cannot be saved by the mere tendering of Exhibit DW2A, the claimant's employment letter tendered by the defendant, and Exhibit DW3A, disciplinary policy of the defendant. The tendering of Exhibit DW2A and DW3 cannot save the situation in view of the paucity of facts and scanty nature of the pleadings before the court. The absence or lack of sufficient materials in the pleadings of the claimant is injurious to the claimant case presented before the court. The law is right that claims before the court are circumscribed by reliefs being sought, and the duty of claimant is to adduce sufficient evidence that will prove his entitlement to the reliefs being sought before the court. This is the case of Cable Metal Nigeria Limited, but RTV versus Cable Metal Nigeria Limited. It is also elementary principle of law that in determining the claim of a party and the issue in contention, the party's pleadings as a whole must be considered as the reliefs must be predicated upon the relevant pleaded facts, giving rise to the claim. The claim or reliefs cannot exist in vacuum, but must be derivable from the facts that donate the right to the claimant. The reliefs donated the right to the claimant or the claims or the reliefs. It is thus settled law that the reliefs claim in a case must relate to, arise from, or be based on the facts set out on the parties pleading, as the pleaded facts being the foundation from which the reliefs must be built or fed, without which foundation the reliefs would have no leg to stand or no structure upon which they can be based. Any relief claimed by claims that does not find its root from the pleaded facts in the parties pleading cannot stand in the eyes of the law. See the case of Amusun versus INEC. Therefore, it is the facts pleaded in the statement of claim or statement of facts that show its entitlement to the relief claim therein. So unless there are facts pleaded in the statement of claim showing entitlement to the reliefs claim therein, then the claim for that relief fails on the pleaded and does not on the pleaded facts and does not qualify for trial. This means a court of law hardly grant orders not sought for or orders contrary to the relief sought before the court, as they are not donors of charity, as the parties are bound by the relief sought in their pleadings. This is the case of Kalio versus Kalio. See also Union Beverages versus Wolabi. See also Liman versus Mohammed, and host of other cases cited therein. In the case of Ishola versus UBN, Calgo JSC, as he then was, had this to say: a relief sought by a party to the suit does not constitute part of the facts. In the pleading, and it cannot be granted unless there are facts in the party's pleading in support of it upon which evidence can be called. It is clear to me that from the pleadings and evidence adduced, the relief being sought by the claimant in this suit emanated from the alleged dismissal of the claimant by the defendant. However, a coupled perusal of the claimant's pleading will show that there is nowhere facts were abad on issue of dismissal of the claimants from the service of the defendant. The claimant's case was built around exhibit A, B, C, D, and E. None of the exhibits standard was a letter of dismissal. According to the claimant, he only read the letter of dismissal and refused to sign it or collect it. There is no oral evidence given given on the dismissal, with the state of the pleadings where there is absence of pleading to establish on his claim before the court. I also note reliefs 1, 2, 3, and 5 are reliefs that the law does not allow to be granted in an action regarding master and servant relationships. Relief 1, which is on declaration, it is court declaration is a court pronouncement on the respective rights of parties without any order of the court that this right should be fulfilled. However, this remedy is available in employee who is able to establish a special legal status as a result of legislation applicable to his employment. The declaration will state whether the termination or dismissal is invalid, illegal, or ultra bias, null and void. That kind of relief is not available to an employee in the case of master and servant relationship, or what is termed common law employment. Therefore, relief 1 fail and same is refused. Relief 2 is for reinstatement of the claimant back to his position as a driver in the company. The traditional common law doctrine applicable to master and servant relationship is that court will not grant specific performance in respect of breach of contract of service. This is because it is not allowed. A declaration that a contract of service subsists will rarely be made. As a general rule, reinstatement is not ordinarily the remedy to the breach of contract of service. Specific performance or reinstatement generally is not remedy for termination or dismissal in respect of personal service. See the case of Imolome versus Wayek. See also Chukuma versus Shell Petroleum Development Company. See also UBN versus Ugo. See also Samuel Igbe versus Governor of Bendel State. See also the case of Epeta versus Shell. This means that this court cannot grant, even if the claimant succeed, this court cannot grant any relief on reinstatement. In the circumstances, relief 2 fail and same is hereby refused. Or relief 5, which is for damages, the law is also settled that an employee has to establish that his employment was wrongfully terminated or dismissed, wrongfully dismissed. And when he establishes that, he is only entitled to claim damages. And the damages allowed is for the period of service, for the period of notice of service in case the contract is determinable by notice. Even where it is not determinable by notice, by the provision of Section 11 of the Labor Act, reasonable notice is required to be given. Another reason why such kind of order is not granted is that the court cannot impose willing employer on an unwilling employee. See the case of Western Nigerian Development Corporation versus Abimbola. See also the case of Imolome versus Waek Supra. See also the case of Nitel versus Oshodi. It is settled law. This claim for the claim for special damages must be pleaded and particularized so that the defendant will know what is to meet before the court. The case of Seven Up Bottling Company versus Augusto comes to mind, where it was held that claims for gratuity, pension, housing fund, salary are all special damages and must be strictly proved. See also NNPC versus Philipo Nigeria Limited. For the claimant to succeed, the burden is on the claimant who claim those monetary sums to prove entitlement to those monetary by to prove strictly. Otherwise, they will not be entitled to any such relief. From all I have been saying above, the claimant in this case has failed by his pleading and evidence before the court to establish that he was dismissed by the defendant. However, from his oral testimony from his under cross-examination, he admitted that he saw the letter of his dismissal with the defendant. He even read it, but he refused to collect it. In such kind of situation, the claimant cannot be heard to complain of his dismissal from service of the defendant when the facts of the dismissal have not been made available to the court. It is only when there is evidence before the court as to the fact of the dismissal and what led to the dismissal, and also whether the dismissal followed the due process, that the court will be able to give an informed opinion regarding whether the dismissal of the claimant was wrongful or was properly done by the defendant. The claimant will have to blame himself for his miserliness in producing evidence before the court to support his case. The pleading of the claimant is nothing to write home about when it comes to the issue of proving dismissal of his service. In the circumstances, the case of the claimant failed and same is hereby dismissed. I make no order as to cause party to bear their cost. Let's call the next case.
Case number NICN CA09M 2020 between Dr. Francis Patrick Udoma, and 1. University of Calabar Teaching Hospital. 2. Ministry of Finance Incorporated. 3. The Attorney General and Minister of Justice, and the Kunduba. My Lord, the parties are
Appearance. Yes.
We need for the judgment credit is tango.
You say you are appearing with who?
U-M-E-T.
Umet.
U-M-E-T.
Yes.
Thank God.
Thank God.
Thank God.
Yes. Yes.
Lord,
65. 20. Yes, what is it about?
God is another attaching the total sum of 5,400 naira. And a second prayer is another great dignity to appear before the honorable court to show for why we should not pay the judgment creditor is some.
Counsel, this your application is not dated. Not dated. Your application is not dated. Why is it dated? Counsel should always be circumspect when preparing this document. When you are filing, you make sure that things are in order. If another counsel comes, you can challenge it. I've just had I read it here now in my judgment that unsigned and dated. Okay, undated document too is not has no evidential value. No. It is tried to know that undated document has no evidential value. So you should be circumspect when you are preparing your processes. Ensure that when you file, all the documents are dated. Yes. Yeah.
But just to call the court attention to the entity attached to 11 paragraph of the standing paragraph. That's a bit. Paragraph 7.
Have you supplied the account number?
Yes, sir. Account number. No paragraph. Yeah.
This your prayer. I'm confused about it.
No.
The prayer, your prayer one, you say an order attaching this total sum of 5,235,666 naira 248 kobo. Then you say 2,397,847 naira 84 kobo. Being the judgment sum in suit number NICN CA 45 2015 and 2,855,817 naira 408 kobo, being 5% monthly interest for failure of the judgment debtor to pay the judgment sum within 1 month of the court's judgment, respectively, due to judgment creditors applicant and standing to the credit of the judgment debtor in his account with the garnishee. An order directing the garnishee to appear before this honorable court to show cause. That one is understandable. But this prayer one, I don't know the way you put the amount.
This was not be, was based on the judgment, the interest. For the court order that is not.
No, there are three different figures you have given. You
Yes.
gave three different figures. What are they for? You should account when a council is filing an application, it should be very clear. It should be very clear so that anybody, even a layman, when he reads it, will understand it.
This was not the concern was that when we find the initial garnishee that we start, what advised that it's the amount as order before not on our own just something. That's why we didn't want them to come around.
You have to sum them, then you now specify. That's what you're supposed to do. The court hereby ordered case dependent to pay claimant the sum of 2,700,000.
So the second one, if the court can allow some
Counsel, you have to show how you arrive at it in the affidavit. Because I don't know how you got this 5 million. Where did you get 5 million? And where did you get 2.3? And where did you get 2.8? That is my difficulty.
Yes, no, because we are we'll make fun.
Give me that. Okay. This one.
No, sorry.
Yes.
So we actually describe it in our that like we talk as right. Describe paragraph 5. What we can have to find is of the loss.
We are in court. I switched off my phone, so everybody here should switch off his phone. This your affidavit has not answered my question. I see there are 3 different figures there. How did you get those 3 different figures? That's my question.
Yes, the judgment sum as paragraph 5 has attracted interest for the past 4 months as per the judgment.
And what is the amount? You have to state it, counsel.
And the amount is
You have to state. You will
Yes,
now
Lord.
say that the main judgment sum is so amount.
Yes.
The interest that accrued from so months to so months per month is so amount times the number of months. It will give me so amount. Then added, if we add so amount to so amount, it bring it to the total sum of so.
Yes, Lord.
That is what we claim,
Yes, Lord.
and that is not what you did in your application.
Yes, Lord. We merely stated the different amount and just added it. We'll do a breakdown.
Supposed to give, because the 3 different figures I don't understand. The 3 different figures you gave on the motion paper, they are not all of them are in the affidavit. You only gave 2. So what of the remaining, the 5 million? How did you get 5 million?
Yes, Lord. It's because the 5 million is the total of the 2 breakdown.
That is not what you said in your application. From your application, you are claiming the 3 amount. Read the prayer. You are claiming the 3 prayer. If I now grant my side, it means they will garnish it. They will set aside 5,200,000. Then they will go and set aside 2.3, and they will set aside 2.7.
Yes, Lord. No, we are not guided. We are not guided. So if in the second part, we can apply to strike out our prayer.
It will not solve the problem.
No, amen, because we are doing it another direction.
It will
No,
not
we
solve
are
the
in-
problem.
Yes, Lord. We are not guided. So take it there.
Which date did you see? This case is adjourned to 16th of May 2022 for further hearing of the motion expert. What's the next case?
Street number NICNC 887 between 1 and 2, Mr. Christopher Ikan. 3, Mr. 18J. For themselves and representative of 150 workers of Calabar Wood Processing Factory Limited and Calabar Wood Processing Factory Limited. My Lord, the third claimant on record, present, others absent. Friends absent.
Appearance?
With due respect,
Yes.
Ikoyi,
I equal.
Ikoyi is IPO.
Yes.
My appearance is for the claimant.
Yes. Any other appearance? Yes. Roland Osioga.
My
Yes.
My Lord, the business of the adoption of our address.
Have you filed your addresses?
Yes,
When?
filed in
19th. 19th of
19th July. And got the address on 14th February.
when did you say you filed the rejoinder?
About this on 14th February.
14th February 2022. Yes, I have seen the address, I have seen the rejoinder, but your addresses are not complete. You have not complied with the rules of court. Well, has he submitted his soft copy? The order 45 of the rules of court says counsel filing final written address shall file this hard copy together with the soft copy. And you have not done that. You have not done that. Mr. Okoye, have you filed your soft copy? But you were here. There was a day I insisted on counsel. You were here in court that you must file the soft copy. You should have taken him. When are you going to file? Check. Can you find any date for them after 7 days? Huh? And Mr. Eh? Is it? Is it?
It's going to be a Thursday after your council. Aside from these days, there's
Submission. Mr. Oga, you did not even you did not put page numbers. The same thing with the point. No page numbers. You know our rules is strict on this thing because it has certain number of pages that you will not exceed. So if you don't put page number, we will know. You come back on 7th of April, try to file the what do you call it, the soft copy. You are not paying any fee. You just submit to the registrar. Then you come back on 7th of April to adopt the final written address. 7th of April, April 7th. This case is adjourned to 7th of April 2022 for adoption of final written addresses. Call the next case.
Number NICNCA 4020 between Prophet and Basilewa. And 1, First Bank of Nigeria PLC. 2, First One Pension PLC. 3, National Pension Commission. My lord, the claimant is in court, defendants are present. Your name, sir. Hillary, your position, sir. Business manager. So your name. MDO Group. Your position. Manager, National Pension Commission. The claimant is the court.
Who is the person you're asking? Is it the Ogun? Is it
Is
the
Manager, National Pension Commission.
which dependent is it?
The church defendant on record.
Yes, appearance.
May you please the court.
Yes,
Please the court.
yes.
With me for the claimant who made stand on.
I have told you if counsel has more than one case, put his cases together so that you at once finish and go. You have not done that. The case you call is not. Even if it is adoption, what you should have done is you either put the adoption case, then you put his one case down. Yes, yes, and the yes, Mr. Yes. I hope you have settled now. Huh? Oh, we are still where we were last time. If you have settled, why haven't you filed terms of settlement so that court will now adopt it as its judgment? Meaning you have not settled because a settlement is by consensus. You have to agree. You have to agree. If there is disagreement, there is no settlement. So where are we now? Where are we heading to? Where is the witness? Let him come and enter witness box. Yes, we have finished virtual sitting. Yes.